So, this week we'll be talking about sex offenders and protection of child victims. Now, first, let me just briefly talk about the sex offender registration laws. So, as many of you may already know, when someone is charged and convicted of a sexual offense, then they may have to end up on a registry. And that registry, in terms of how long they have to register, can vary based on the offense. These offenses can include anywhere from public urination to child pornography to actual sexual assault, rape. So there's a wide variety, and how long someone can end up on there, 5 years, 25 years, life, really depends on the type of offense. But ultimately, the label effect is the same. We in our society will view a sex offender the same way, almost regardless of what their offense is, unfortunately, and without really considering what was the nature of the offense. And the reason why I say it's somewhat unfortunate is because for some people, the offense could literally be, urinating in the park. And I'm not saying that that's not an appropriate thing to do, but to get the label of being called a sex offender, it carries a very, very strong stigma that people associate with actually assaulting someone. But a lot of people don't know that it doesn't necessarily have to include someone actually doing something to someone. And registration laws is a collateral consequence. So it's not a direct consequence of the offense, but it's kind of secondary to it. So the direct consequence is you might go to prison, right? But then secondary to that, you end up on a registry. Kind of similar to how someone might lose their voting privileges for having a felony and going to prison or something to that effect. It's secondary. It's a secondary kind of after the fact punishment. Now, in Kansas v. Hendricks, which is the case you've read, the U.S. Supreme Court stated that the sexual violent predator statute was essentially commitment that was civil. And what the court says, well, it wasn't a violation of ex post facto. Number one, because it's for purposes of treatment. It's not punishment. It is not punishment. The civil commitment is not punishment under the sexual violent predator statute. It's a form of treatment. And therefore, it doesn't violate neither the ex post facto clause, nor does it violate double jeopardy. And the court goes further to say it doesn't violate double jeopardy because the act itself, or at least the act, a sexual violent predator act, does not require someone to have a criminal conviction as a prerequisite for them being committed. So it's not a form of double jeopardy. And lastly, Maryland v. Craig. At this point, after you read this case, a little light bulb should have went off. I said, I remember reading something like this. Well, remember at the beginning of the semester, you did the Iraq discussion example. Well, the Iraq discussion example was based loosely off of this case, the Maryland v. Craig. And what the U.S. Supreme Court said in this case is that the Maryland statute, which allows a child to testify via closed circuit television, was not a violation of the Sixth Amendment Confrontation Clause. Now, the Confrontation Clause is that right to confront your accusers. And the Supreme Court argues that the reason why we have the Confrontation Clause is because we want to get at the truth, right? It's much harder to lie to someone to their face than behind their back. But what the court says is in these situations where the child might be vulnerable and impaired in their ability to communicate in the presence of the defendant, well, then you're not going to get at the truth. And the whole purpose of it is to really get at the truth, right? To be able to confront your accuser, to get at the truth. And so they said, but ultimately, the child can testify via closed circuit television, and the defendant can communicate with his attorney, which still, and so that defendant's attorney is in the room cross-examining the child, and the jury can watch all of this. So it preserves the spirit, as they say, of the Sixth Amendment. It preserves the right of the defendant to still confront their accuser. It still allows us to get at the truth, because by watching it, the jury can still assess the credibility of the child based on the child's body language. And it's also because there isn't an automatic kind of like every child, by virtue of being a victim, will testify via closed circuit. There was some sort of independent finding by some sort of psychiatrist or psychologist who said that the child would be impaired in his or her ability to communicate. And so because of that, they said, well, there's this added layer of protection, at least in this particular, with this particular statutory scheme, because they have to first find that child would not be able to communicate. And then this statutory mechanism would kick in, and the child would testify behind closed circuit television. But again, the defendant would be in touch with his attorney, closed circuit television. The defendant would be able to ask his attorney questions, say certain things to his attorney, while the attorney is questioning the child, and the jury would still be able to watch all of this. So they felt like everything about the Sixth Amendment Confrontation Clause is preserved. And as you'll notice from the readings, many states have adopted some version of this Maryland statute since Maryland v. Craig. So you'll see that 121-page document. You don't have to read the whole thing, but it's just there to show you the volume of the states that have borrowed something like this. And some people are really kind of, felt like this is a little bit a slippery slope. People like Scalia, some of the conservative justices, argued that this really removes the face-to-face, which they believe is a hallmark of the Confrontation Clause. But the majority erred on the side of basically saying that right is not absolute. The direct face-to-face is not an absolute right. And also, back to the Kansas v. Hendricks case, I just want to say real briefly that sex offenders are the only class of offenders that we do that to. We don't do that to any other class of offenders. Other people who commit crimes. I mean, you have somebody who commits arson, attempted murder. When they finish serving their sentence, they leave. They leave prison. Yes, they'll be on parole. But sex offenders are the only ones where on their way out the door, we'll turn around and we'll commit them for purposes of treatment. And some people in the mental health community, as well as the legal community, really kind of says this is a very slippery slope. And the recidivism rates are relatively high, but they vary based on the type of sex offense that the person has committed. And so the extent to which we actually can sit up there and say, well, there is this treatment that, will stop them from offending or reduce their risk of reoffending, kind of puts the onus on the mental health community to do something that some people in the mental health community feel should not be put on the mental health community. Essentially, they felt like it was a legal workaround that then put it on the mental health community to fix because it was a mental abnormality that allowed for the commitment of the individual for treatment. So from the readings, you'll see that there is this kind of split. There's kind of these two sides where some people think it is an appropriate use because this is what we do, and the other side says, well, no, this is a problematic application of the law to put this on the mental health community to treat these individuals and provide some argument under this legal justification that it's for treatment. And so there is some resistance to it, as you'll see from the readings this particular week. And with that, this is the last PowerPoint, and hopefully you found this course very informative, and I wish you all the best.